Let's dive right into this explainer, where we're going to unpack how the incredibly strict procedural rules of the Supreme Court scale up. We're talking about a jump from simple, everyday property disputes all the way to massive, unprecedented questions of international law. Today, we're breaking down the legal frameworks at play in a truly high-stakes Supreme Court case, GR No. 278747. That's former President Rodrigo Roa Duterte and Senator Ronald Dela Rosa versus Executive Secretary Bersamin and other officials. It is a fascinating look at how the machinery of justice processes literally everything, from throwing out a civil complaint to enforcing international arrest warrants. Here's a quick roadmap of where we're headed today. First, the rules of procedure. Second, the ICC warrant petition. Third, customary international law. Fourth, extradition versus ICC surrender. And finally, number 5, injunctions and unclean hands. Section 1, the rules of procedure, establishing the baseline. Now, to truly understand how the Supreme Court evaluates any case, even one involving a former president, we really have to look at its strict, unyielding rules of procedure first. We're actually going to start with a seemingly simple property dispute, the Sadwani case, just to prove a crucial point. These foundational rules, they apply to everyone, completely regardless of the stakes. Okay, so there is a super nuanced difference between failing to state a cause of action and lacking one entirely. Now, I know this might just sound like legal jargon, but it's actually the ultimate gatekeeper for whether a lawsuit survives its very first day in court. Failure to state a cause of action basically means your initial pleading just doesn't have the right allegations to even warrant a case. You can raise this right out of the gate. On the flip side, lack of cause of action means you don't have the actual facts or evidence to back your claims up, and you can only figure that out much later after evidence is actually presented. In the Sadwani case, the trial court completely blurred these lines, which, in the eyes of the Supreme Court, is a major procedural misstep. The thing you have to remember about the Supreme Court is that how you argue is just as important as what you argue. They simply do not forgive using the wrong paperwork. In that same property case, the trial court dismissed the complaint without prejudice, meaning, hey, the plaintiffs are totally free to just refile it. But instead of doing that, the heirs tried to file a regular appeal under Rule 41. The Supreme Court immediately stepped in and said, no, absolutely not. An order dismissing an action without prejudice is not appealable that way. You either refile it, or if you really think the judge committed grave abuse of discretion, you file a special civil action under Rule 65. If you use the wrong legal remedy, your petition gets dismissed outright. Keep this strict adherence to the rules in the back of your mind as we raise the stakes. Moving to Section 2, the ICC warrant petition, raising the stakes. Let's get to the core focus of our explainer. Those exact same strict procedural expectations we just saw in a basic property dispute, they are now being applied at the highest level imaginable, where the petitioners are a former president and a sitting senator facing international warrants. Over the past decade, a really complex sequence of events has led us to this legal showdown. Back in July 2016, the government launched Project Double Barrel, the nationwide anti-drug campaign. Fast forward a bit to March 2019, and the Philippines officially withdrew from the Rome Statute. However, the International Criminal Court continued its investigation into acts that happened prior to that withdrawal. And that brings us to March 2025, when the ICC issued an arrest warrant for former President Duterte, which was then followed by a warrant for Senator Dela Rosa in November 2025. The petitioners are trying to block these warrants, and in response, the Office of the Solicitor General, the OSG, filed this massive 73-page comment. It lays out the state's entire legal interpretation on exactly why these warrants can and should be enforced. Before we get completely lost in the legal mechanics, the OSG's comment takes a moment to establish the factual context and the sheer scale of the campaign under investigation. Just looking at July 2016 to November 2017 alone, there were over 79,000 anti-drug operations and more than 118,000 arrests. Crucially, the official figures note 3,967 individuals who died during these operations. Now, the OSG comment does acknowledge that independent estimates place that number much, much higher. But it's the unprecedented scale of these events that ultimately trigger the ICC scrutiny for alleged crimes against humanity. Section 3, Customary International Law. The state's legal obligations. Now, the petitioners are arguing that because the Philippines withdrew from the Rome Statute back in 2019, the ICC has absolutely no jurisdiction, meaning the Philippine government has zero legal basis to enforce these warrants. Let's look at how the OSG counters that argument. The OSG anchors its counterargument really heavily on a legal concept called jus cogens. Think of this as the ultimate trump card in customary international law. It's a compelling rule that binds all states, totally regardless of what their own domestic laws might say. Crimes against humanity, which is what the ICC is alleging here, fall right under this category. Because of that, the OSG argues that these crimes hold universal jurisdiction. Their stance is that the state is legally bound to cooperate in prosecuting these core international crimes, and that obligation exists completely independent of whether they are an active member of the Rome Statute or not. To bridge the gap between international law and domestic enforcement, the OSG points straight to Republic Act No. 9851. That's the Philippine law that penalizes crimes against international humanitarian law. The OSG interprets this domestic law as operating completely on its own 2 feet. They're arguing that it actually grants the executive branch the authority and the discretion to bypass domestic prosecution and instead surrender an accused person directly to an international tribunal that's already investigating. In their view, the mechanism for surrender is already baked right into domestic law. You don't even need the Rome Statute for it to work. Section 4. Extradition versus ICC surrender. Distinct legal mechanisms. The petitioners are arguing that trying to hand them over to the ICC violates the strict rules that govern extradition, and this sparks a massive debate over which legal mechanisms we should actually be looking at. The OSG draws a really hard line here to separate these two concepts. Extradition, they say, is a bilateral, state-to-state process governed by very specific mutual treaties. ICC surrender, on the other hand, is a multilateral process specifically designed to address core international crimes, governed domestically by RA 9851. The OSG claims that Senator Dela Rosa is basically cherry-picking domestic extradition rules to add an extra layer of litigation and create a shield against an international criminal process. They argue that standard extradition rules just simply do not apply to an ICC surrender. Finally, Section 5. Injunctions and unclean hands. The fight for judicial relief. This brings us right to the immediate tactical maneuvers happening at the Supreme Court. Senator Dela Rosa filed urgent motions seeking what's called an injunctive writ. Basically, he's asking for a court order to stop the executive department and law enforcement from arresting him while the Senate is in session. But remember those strict rules of procedure? To unlock this kind of extraordinary relief, you've got to clear 3 very specific legal hurdles. First, you need a clear right currently in existence. Second, there has to be a material invasion of that right. And third, an urgent necessity to prevent serious damage. The OSG argues that the petitioners completely failed on all 3 fronts. For example, they point out that Senator Dela Rosa hasn't shown an actual consummated deprivation of his liberty. By his own account, he was able to go into the Senate, participate in sessions, and even vote on leadership changes. The OSG argues that the mere threat of an arrest warrant is an anticipatory action. It's not an actual invasion of a right that would justify granting an injunction. This is where the OSG's argument gets really sharp. They bring up the equitable nature of an injunction, which means the person asking for court protection must come to the court with clean hands. According to the OSG's timeline, right after the warrants were publicized, Senator Dela Rosa sought the protection of the Senate. But shortly after that, he reportedly sneaked out of the Senate premises early in the morning to evade law enforcement. The OSG claims that this physical flight literally classifies him as a fugitive from justice. And under the law, if you're a fugitive refusing to submit to the authorities' jurisdiction, you are legally barred from seeking the equitable relief of an injunction. As the OSG sees it, you absolutely cannot evade the law's reach while simultaneously demanding its protection. We're going to leave you with this pretty profound question pulled directly from the OSG's comment to the Supreme Court. It perfectly captures the tension at the heart of this entire explainer. We went from the incredibly strict procedural requirements of a simple civil property dispute right up to the heavy, universal obligations of customary international law. The rules of procedure are designed to be entirely objective. So this case really challenges us to consider the ultimate purpose of the rule of law. What do you think? Is the law just a tool to be selectively invoked for evasion, or is it a universal standard that guarantees accountability no matter how powerful the individual might be? Thank you so much for joining me in breaking down these fascinating legal arguments.